That's great. Okay, Dr. Fry has been a shining example of what public service means for decades now, with accomplishments that are too numerous to mention, from her practice as a physician to her service in government and in opposition. We're very grateful that she's taken up the issue of protecting elders in long-term care facilities from operators, owners, and companies that fail to provide the necessaries of life with her introduction of Bill C-295. Now, I know that we're all anxious to hear from Dr. Fry on this topic, so please give her a warm welcome, Dr. Fry.
Thank you very much, Trish. I just wanted to say that the reason I brought this bill forward, is because as a physician, I have seen this happening slowly in terms of the institutionalization of seniors in my province of British Columbia. And some of the things that they're not able to access, some of the things that they have been denied. And so it was something I would talk about locally within BC. But when COVID came, COVID actually exposed the really dire nature of the situation across the country. And it was something that everyone expected the federal government to do something about. But here's the thing. I know everyone thinks that we always go jurisdiction, jurisdiction, jurisdiction. Fortunately or unfortunately, whichever way you want to look at it, we have a constitution, and that dictates who is responsible for what. Currently, the federal government is responsible for healthcare in that, under the Canada Health Act, which was brought about by Monique Béjean under Pierre Trudeau's government, the federal government sends money under 5 major principles to provinces in order to deliver the accessible, universal, quality healthcare to Canadians, regardless of where they live or regardless of their pocketbooks. There is an act that governs that. But really, at the end of the day, once the federal government does that, all it can do is penalize a province if it doesn't keep the traditions and the principles of the Canada Health Act, and if it circumvents it. And so the provinces are responsible for delivering the actual healthcare, delivering it where they deliver it, how they deliver it, to whom they deliver it. Well, of course, they cannot exclude anyone, but they are responsible for all of that detailed thing. During the Canada Health Act, there were some things that were not agreed on by the provinces that the federal government should have some kind of say over. One of them is long-term care, assisted living of any kind, whether it is for seniors, adults, or even children. We have no jurisdiction over any of that. The provinces do. Or what the healthcare facility looks like, what it provides, etc., as long as it's there to give people the care they need when they need it. And we've seen that this is spotty, therefore, across the country. So 10 different provinces, three the Yukon, Northwest Territories, and Iqaluit, they all are Nunavut. They have all their own say in how they do things, and the federal government doesn't really have an ability to give them heck unless they break the Canada Health Act, in which case we have the ability to withhold money. So when all of the problems, especially in Ontario and in Quebec, surfaced with regard to the long-term care of seniors, it really showed the world, well, in Canada, what the problems were and how the federal government didn't have an ability to do anything about it except send the army in to help to provide the situation and relief. The report that came out after COVID gave all of the chapter and verse about where things went wrong. The people employed in these long-term care facilities, many of them were not really trained. They weren't all RNs or nurses or trained people. Some of them were just people who were just, there to fill a space because a lot of these long-term care centers didn't pay people appropriately. So They would get people for whom English was not a first language, for whom the ability to read instructions and follow them, the ability to be a healthcare provider that's credentialed, isn't always so. There are obviously doctors and nurses working in these facilities, but they don't always provide the day-to-day care. And so we found that protocols were not obeyed. Nobody was looking at the issues with regard to mask wearing, with regard to cleanliness, with regard to ventilation, which we now know is a big deal. And what happened is we found in long-term care units, disease spread like mad because the ventilation system was one ventilation system that blowed air from one room to another and across and around the whole facility. So I think the federal government really could say from the results and the report that came out that this didn't work and that we had to bring in the armed forces. And the army also gave a report that said things were so terribly bad and not managed properly, et cetera, in some areas. So I felt that the only thing that we have as a federal government is a criminal code. There is a legislation that talks about the failure to provide the necessaries of care for children. That's in the criminal code. But there was nothing in the criminal code to talk about vulnerable adults. And so it's not just seniors and COVID, it's disabled persons and people who require assisted living assistance. No protocols across the country that we can say this is a protocol across the country that everyone should obey. We know that the Canadian Standards Association put out protocols following COVID. But again, nobody can make provinces follow those protocols if they don't want to. Because once again, I want to remind you, the federal government has no authority over long-term care or over those kinds of institutions, whether it be mental health institutions or otherwise. So basically, I felt that the only thing to do was to look at the failure under my bill, which is Bill C-29. It's called neglect of vulnerable adults, and the failure to provide the necessaries, and necessaries, you may think necessities is the word, necessaries is a legal term, to provide necessaries to vulnerable adults in an institution of two or more people. And that rules out if you're looking after mom at home or you're looking after granddad at home. You don't want to sort of put parents and siblings and stuff in that situation. So this is about an institution. The ability to define an institution was three or more people delivering this care, not in the home, not in the domestic setting. So it really applied, therefore, to long-term care centers, some kinds of institutions that were looking after vulnerable adults. And so what it does is to basically say, and it was going to hold responsible the managers and of these facilities and the owners the responsibility. If that facility failed to provide the kind of quality of care that was required in a facility, then they could be taken to court, and the courts could have an ability to rule on whether they were negligent or not. But you know, the interesting thing about that is that when it has the support, or so we are told, and so I am told when we presented it to committee, it went through first reading in the House, second reading in the House, and then it went to committee, which is how bills start with first reading, second reading, then the bill goes to committee. And the committee is the place where a bill gets amended, changed, new things put in, some things put out. It's where it gets to be debated by the committee members. So basically, when it went to committee, everyone liked it, but there were things they felt they didn't like about it. There were some things they felt needed to be changed. And one of the big ones was that people said, who is a manager and who is an owner? What do you mean by that? And so the problem is that you could have a nurse looking after the facility as a quote unquote manager, but that nurse may not, or that doctor may not have any ability to fund it, to make the kinds of decisions that are made by someone who actually owns a facility. And as you well know, a large number of facilities in Canada are run by private sector. In some provinces, most of them are run by private sector. Some of them by people who make a profit, some of them by NGOs, churches, etc., who do not make a profit. And so, and then of course they're the government run, but they are fewer than the general rule of thumb is private facilities are doing it. That is something that, that's another story, and that's something that one can discuss. But in this initiative, what people suggested at the committee, all of the political parties agreed on the fact that we should change the title of owner and manager to be replaced by officer, and a definition of officer. And it means an officer means the chairperson of the board of directors, the president, a vice president, the secretary, the treasurer, the comptroller, the general counsel, the general manager, or a managing director of a long-term care facility. Any other person who performs functions at the facility similar to those normally performed by a person occupying any of those offices or any other person designated as an officer of a long-term care facility. Everybody felt that that really didn't penalize people who were just doing what they were told they could do, and who may have said, I don't think this is good enough, I don't think this is what we need to do, and who have no authority to change it or no authority to do anything about it except to complain. So that was a definition that was changed at committee. A lot of people liked it, and so what happened? It went to committee, came out of committee with a couple of changes, and then it's going to come back on what we call third reading, where the committee presents its findings to the House. Then there's a little debate, and then it's voted on. If it passes, and this is going to happen on the 26th of September, if it passes, it has to then go to the Senate, where it goes through all the iterations in the Senate, where it goes through all the committee work, and the Senate will make whatever changes they want in it, etc. At the end of the day, it does not become law until all of that happens. So we still have a little ways to go. Now, private members' bills, which is what this is, and our government supports me in this private members' bills. In fact, we have a fair amount of ability to talk about the legal wording to make it work. Then we had help from the Justice Department telling us what are the things that we should think about when we're doing legalese, because I'm a doctor, I'm not a lawyer. So we had all of that happen. So that was all carefully helped. So my government supports it. However, we need, because we're a minority government, we need the support of either the Bloc or the NDP or the Conservatives. Happily, everyone, after they discussed it, and I presented to them, and they asked questions and hashed it over, and they made a couple of changes, as I told you, defining clearly what an officer is. Now, so that's where we are with the bill, and I'm prepared to answer any questions about it.
Okay. So that was the introduction. If anyone has questions about the bill or anything else that you'd like to ask Dr. Fry about this, please speak up now. You can put your hand up. That would be helpful. And the way you put your hand up is go to the bottom of your screen. It says reactions, and you'll see if you click on that, it says raise hand. Okay, we have Ingrid Dandanel raising her hand. Ingrid, go ahead and ask your question.
I'm just unmuting. I'd like to point out how really rare it is for a private member's bill to receive royal assent. So kudos, and this is absolutely awesome. It is incredible. Mm. Do you feel that this will, in the long term, perhaps take away any movement to aging in place? That people will think, well, we fixed the problem with long-term care. Now we don't have to worry about those, and here I'll use blankety blank people who want to age in place rather than go into long-term care. That's a concern that I have with this.
Yes. it's not going to have any effect on people who want to age in place. Because the minute you decide to age in place at home, then it's not an institution anymore. It's not a facility as defined in the bill. And we are very clear to make sure that it means that you cannot use this law against your kids who are looking after a senior person, or the siblings are looking after a senior person. And so we set the number of people to make it become a facility that are doing the care, and make sure that they're not family members.
No, that wasn't the intent of my question. My concern is that the will of Parliament will be that they will not give the proper supports necessary for people to age in place because they will have dealt with long-term care facilities. So I'm looking at an us-them.
Yeah, I think
I hear what you're saying,
Dr. Fry,
yeah.
Dr. Fry, if I can just clarify, I think the issue is people are concerned that if the federal government believes and provincial governments believe that the institutions have been fixed, that they don't have to put more into people who wish to age at home. They can just go into the institutions. Is that right, Ingrid?
That's what I'm getting at.
I think that's what the concern is.
All of the evidence is showing that people who age at home and age in place actually have a lot better outcomes. Yeah. But there are people, as we well know, who are going to have to go to institutions, mainly because they have no children, they live alone, they have no one to look after them at home. They cannot age in place, even if you put in the right physical supports for them and give them a supportive system. They're going to have to get somebody to come and live at home and help them look after them. So some people are very, very ill and immobile and all kinds of things and don't have that ability to want to do it. Some people really want to go somewhere where they can be cared for day to day and get their food cooked and done, all of that. So this is not anything about who goes and where you age. The federal government is looking at, and most provinces have agreed, that aging in place gives you better outcomes. So there are all the other policies that are being given and worked out to help people age in place, like caregiver supports for family members who are looking after somebody at home, like that ability to have the kind of support systems you need to work at home. Those are all moving forward. Those are all actually becoming more and more entrenched. So I don't think you should worry about that.
Okay, that's great to know that those initiatives are going forward. Just to let you know, SSAO has also recommended residential alternatives to the institutions. So for the people you were talking about who need the residential care, SSAO is recommending that elders have the same access to the small homes in the community that every other disability age group has. So that's one of our recommendations, because we do know that there are people who will need residential care. We just don't think it has to be in an institution. So just to clarify that.
Well, the definition of an institution is not as hard and fast as you like to think. In our bill, we actually defines more than 3 people who are not family who are looking after the person. So it's not a case of where the person is looked after. It's who is looking after the person.
Right.
We don't want to penalize families who are doing the best they can. We want to talk about the fact that if there's more than 3 or 4 people in this facility, residential home, whatever you want to call it, that are being looked after by people who are not their family, then obviously that becomes a facility under the bill.
Okay, that's great. That's a great clarification. I have Lady, Darlene, Trish, and Joy. So what, Lady? I don't know your name.
Hi. Yep. Hi, my name is. Yeah. Okay. So my question is around, enforcement and penalties. I'm in Ontario, and there is significant provincial legislation around how long-term care homes are supposed to function. And when it doesn't function correctly, there is a telephone number you can report it to, and out comes a little piece of paper, and everything just continues. I'm wondering how your law could make that different.
Well, in at the committee stage was added a part that said we have to consider provincial laws, and provincial laws that are actually not providing necessities will be seen by the judge as a factor to be factored in.
So, but this would be I guess what I'm getting at is, rather than being sort of a civil law where, you know, even if maybe the report comes out and says, yeah, they did it, but nothing changes in the nursing home, your only recourse really is to sue if you can, because it's civil law. Since this is a criminal law, would the police arrest the director of care? Would they face a fine or a penalty if the law is broken? How would it go?
They will face penalties in terms of fines. Fine. They will also not be allowed to take care of vulnerable adults for whatever period of time the judge deems to be the number of years that they should stay away from looking after vulnerable adults. So there are those kinds of penalties that are happening. Obviously, it could mean that if it's large enough violations or massive violations, and they may shut down the institution itself. But I mean, that's up to a judge. The judge will make a decision based on the evidence, based on what they're hearing, what they're seeing, et cetera, et cetera.
Okay.
Okay, that's great.
Did that answer the question?
I think it does. I think it does.
Okay.
Very good answer, in fact. Okay, Darlene, then Trish Rostone, then Joy. So, Darlene?
Sorry, just trying to unmute there. Thank you very much, Dr. Fry. I really appreciate that you're doing this as we all age. But I also have a daughter in a facility, an adult daughter that's autistic. So, you know, these types of things, she's can't speak for herself. So I'm glad that, you know, you're championing this. What my question is, I believe I know the answer, but it is the federal provincials that you want, right?
Well, no, the federal government's criminal code can look at what is going on across the country in many ways. If it is a violation of rights, and obviously in this case it would be the failure to provide the necessities, will be seen in the criminal code. There is similar legislation that looks at children in care. We're just saying it should be vulnerable adults, and it means it doesn't only have to be seniors, it could be your daughter.
Yes, or sorry, I said, and the federal provincials, I meant that, like the conservatives. I still want to call them the PCs, but the conservative, it's the federal conservatives that you want, right, on your side?
Well, they say they like it. They say they will vote for it. I don't know. Sometimes you find that private members' bills, everybody says, oh yeah, and they get involved at the committee stage and they talk and talk, so it looks like they're interested. And then the time comes and they don't vote for it.
Yeah.
So, but we have been promised support by the NDP. And of course, if the NDP votes for it, and as a minority government, we have the numbers to pass it. However, there are very few NDP in the Senate, so who knows what the Senate will do with it. But there are many doctors in the Senate who care about this issue.
Great, thank you.
Trish Rostone, you're next.
Thank you. Thank you very much. I listened to your speech and listened to everybody else's comments, and you dealt with all of the questions in an excellent format, so that I was guaranteed that someone would be looking out for those in long-term care. I'm also wondering about whether or not, I've heard so many people that have legalese behind them saying, we already have a criminal code. Why do we need one that is separate for this particular institutional setting? We know that home care, because Manitoba Law Reform Commission did a commission about elder abuse in home care. They wouldn't touch long-term care, but they did home care, and found out throughout Canada there are so many vulnerable seniors that are being abused and neglected there by home care staff. And I just wondered, there's no owner there, but maybe there is now that we have so many home care that are under for-profit agencies now. Do you see this as being an issue that we could include these people?
Well, I think the issue is about long-term care. And we have defined very clearly what constitutes a facility. And so a facility could be your home. What we want to make sure that we're not saying it's your kids or your family members. And so it clearly says if you are not a family member. So it exempts family members. Now, obviously, many of us know that that's a little bit Pollyanna-ish. There are family members who do abuse their parents or their grandparents or whatever. But the bottom line is that the province is taking care of some of those things already. The problem about this is that everything is very provincially based. Some provinces have legislation, some provinces don't. Some provinces have protocols, other provinces have different ones. And so we need to pull it all under one rubric. And the Canadian Standards Association, after this report, actually wrote a set of guidelines and protocols for delivering necessaries of life to a vulnerable adult, and what those must be and what are the protocols. So everything is written in a neat little package for people to say, we're going to follow those protocols. And if we don't follow those protocols, then obviously we're violating and not providing the necessities.
Right.
So
thank you.
Okay, thank you, Joyce. Seguin?
Hello, Joyce Seguin from Cornwall, Ontario. Thank you, Dr. Fry. I can't express enough my gratitude for you doing this on different levels. Like Darlene, I have an adult son with a profound developmental disability who is nonverbal, incontinent, etc. And when COVID struck in long-term care facilities, it was kind of bittersweet, whereas, you know, I was really pleased that it brought awareness throughout Ontario and throughout Canada. However, again, our population of people with disabilities were sort of in the background. I'm sure you're aware that there are so many similarities in care in facilities with seniors, what they went through, and what our adult children are going through on a day-to-day basis as well. So I really thank you for including our adult vulnerable people. And you've clarified a lot of my questions that I had regarding the definition of long-term care facility. And I do know that it's sort of defined in there, adults, including disabilities. When I hear the word long-term care facility, like most people, I think we go to long-term care facility for seniors and not necessarily wrap our heads around adults also with developmental disabilities residing in residential homes, community homes with 3 or more people. And I understood by, I'm sorry, the lady who's hosting this mentioned that you're looking at offering residential care versus long-term care. I think it's an excellent idea, but remember, these things are happening in residential care for our adults with developmental disabilities. It's like little mini institutions. So having a law, not in all, there are many, many wonderful places as well. You know, I want to be straight on that.
Yes,
but
there are
too many that aren't. And I think it depends on the management and the officers of the time. So having a criminal code is so important. And I have a senator, a lady who was a mayor here in Cornwall who became senator, Bernadette Clements. And I think I'm going to reach out to her and I'm going to try to make sure to encourage her to do the right thing here, you know?
Well, you know what? That's how things work in politics. You call up the people that you know, that your local MP. We are told by the local MPs that all the parties are going to support this. I have, You never know what happens when we vote on the 26th of September. But if you know senators, the thing to do is to call them and tell them you're interested in this, that this is very important to you. And, send them letters, do what you need to do to make sure that the Senate does not throw this in the waste can.
Well, I have contacted my MP on numerous occasions, inviting him to attend one of these webinars that I've attended throughout the past several months. He wasn't sure what it was about. And so I'm educating him.
Good.
Yeah. And
That's all.
All of us
about tonight.
MPs need to be educated. When I became an MP, I knew all about medicine, and I knew about evidence-based blah and evidence-based blah. And I had a lot of ideas about housing and education. I knew nothing about the automobile sector. I knew nothing about agriculture. I thought eggs actually came in a box on the supermarket shelves. I didn't know anything about anything. And I had to depend on people to educate me about how these work and what are the rules and regulations. And the interesting thing is that the federal government has no ability to make provinces all go by one standard. The federal government cannot impose a standard across the board, but it can. And because of the Canadian Standards Association setting up protocols, we can say, here are the protocols the Canadian Standards Association set up. So that becomes a guideline for when, the courts are looking at it. They can say, well, hey, you failed to meet any of these guidelines, people. I don't care what province you're in. It means people are going to pull up their socks. They're going to start looking at setting clear guidelines and clear protocols for the care of vulnerable adults.
Yeah. Okay, thank you. Thank you for that. And Patricia Pepper, I see your hand, but hang on one moment.
Hi, Patricia Pepper. How are you? Patricia is an old friend.
I just had two questions I want to slip in that people gave me who couldn't make it to the session. The first question was, why was this introduced as a private member's bill as opposed to a government bill?
Because government bills quite often can take a long time to get through the House of Commons. Mainly because you have to get a bill to be getting onto the floor of the House. All the parties have to decide they're prepared to discuss it. Some parties block it. It can take a long time. And I think people don't understand that sometimes they say, well, the government said it was going to do this and it never did. It's because there's negotiation behind the scenes for people to say, we need to debate this in the House on the floor and get it out there. But private members have like a roster in which they literally pull a straw. And if you get the right straw, you get right ahead of the game and you get to put your private member's bill. And there is private members' bill time in the House of Commons every day for private members to bring forward the legislation they want. It also allows for sort of equity in the House of Commons where you don't have to be a government member to get something done. You don't have to wait for the government alone to do something. Now, some private members' bills, if they're going to cost a ton of money, may not get passed because there is no ability for private members to tell a government how to spend money. But there is an ability, and many private members' bills have been passed dealing with animal welfare, dealing with a lot of things in the past. So it's a good kind of equalizing system that gives people the ability as an MP to come forward and say, my people in my riding, in my province, in my city are really having a problem with this. And it's federal jurisdiction, and I want us to do something about it.
Okay, that's great. That's a great explanation. The only other question before we go to Patricia is around enforcement of the criminal code and enforcement of the bill. There are a lot of people who have told us, and especially the families of the people at Orchard Villa, who raised the whole issue of necessaries of life not being provided to people at Orchard Villa. The military went into that facility as well. It's a Southbridge facility in Pickering. And what happened is that the police refused to investigate. They just said they'll look at it, but they never bothered to investigate. So their question is, what would the enforcement be? Will the police have the opportunity, I guess, to ignore this section of the criminal code like they had ignored the previous section on necessaries of life?
Well, there was no section on necessaries of life for vulnerable adults in the criminal code, only for children. And the police must look at violation of a law in the criminal code. They cannot ignore it just because they don't want to. Now, I know, again, we're not being Pollyanna-ish to know that sometimes the police can turn a blind eye to certain things. But I think the point is that this is now a piece of law in the criminal code under already existing law that deals with children.
Mm-hmm. Okay, so it's the specifics that are going to make the difference, hopefully.
Yes.
Yeah, okay. Because in the 1980s, actually, a criminologist, Dr. Beata Jorgensen, wrote a report where she outlined criminal acts against elderly people in institutional care. And at that time, there was an Ontario Provincial Police investigation that was begun at the request of the Attorney General and the Solicitor General. We have tried again to get that to happen, but so far, no dice with the provincial government. So it's one of the reasons we're grateful to see this go into the act as well, just to make that comment. Patricia, yeah. I think Dr. Fry is eager to hear from you.
Hi, Hedy.
Hi, Patricia. How are you doing?
Great, thank you. Yes, very busy here with the, we had the by-election and we got Karen McCrimmon elected.
That's good. That's very good. Karen's a solid a person who really cares about serving the community very well. So I'm glad to hear that. That's good.
She's going to Queen's Park. Anyway, Hedy, obviously you've done a lot of homework on this. 2 or 3 questions for you. Number one, does your bill define vulnerable adults? We've heard that from people tonight that have adult children in residential care. And when you think of vulnerable adults, you immediately think of long-term care, but obviously it's all encompassing. So I wondered if you had a definition in the bill of vulnerable adults. Second, I'll quickly my second question and then you can go. Is there a European or a British precedent for this, Hedy? You know, in Britain, they had thousands of deaths in long-term care. I wondered if they had anything that was comparable, or had you looked at the British model?
The thing about looking at the British and European models is that, unless you probably looked at Germany, is that we have a different constitution. Our federation is constituted differently. Britain takes care of the British in the whole British Isles that are under their jurisdiction. There is no ability to give that kind of can't give jurisdictions that are solely provincial. In the state in Australia, some states have purely state jurisdictions that the federal government cannot do anything over. But I noticed in COVID, the Australian federal government just went like, we don't really care that, you are the states and we can't tell you what to do. We're going to tell you what to do in this instance. So it's an emergency. It's a pandemic, and it's something that we need to protect Australians. So the bottom line is the biggest problem for us in Canada is that's not a problem, but the biggest challenge is working within the Constitution and within federal jurisdictions that are defined in the Constitution. And this is where this kind of like did a little loophole, found a loophole and put it out there and hopes that it's going to work. Now, Devin, my staffer, is here, and Devin is my legislative assistant. Devin, you might have the bill in front of you. Can you tell us what the definition of vulnerable adult is?
Just give me 1 second.
Okay.
Okay, did that answer your question, Patricia?
Yes.
Okay, that's great. I have Mickey's hand up next, but we're just going to wait for Devin. Give him a moment.
Are unable to provide themselves with the necessaries of life by reason of age, illness, mental disorder, disability, or frailty.
Okay. Does that come through? Patricia?
Yes, it was. And is it somebody over 16 or over 18, or is it anyone with those disabilities?
Adult, as soon as you become an adult, and I think that's 17 for the sake of the criminal code, I'm not sure. So it'd be 17 and over. And it's by virtue of frailty as well.
Yes.
Not just disability and age and any of those things.
Hedy, have you had any resistance from Quebec? As you know, Quebec, they like to pass their own laws. I wondered how they were towards this.
Well, the Bloc Québécois were not necessarily at the very beginning happy to endorse it. They kept thinking, they basically said, which I think most people of the committee kind of like, didn't believe a word of, that they had done a very good job with COVID in their long-term care facilities. And of course, everybody knew that wasn't true. So they just were saying that, and then they left it alone. They don't like the federal government to tell them what to do in Quebec. You're absolutely right. But again, they are still subject to the criminal code.
Thanks, love.
So they came forward with some very solid and good amendments.
Oh.
Okay, that's great. Thank you. Mickey, you have a question?
Yes, so this might be like really basic, but what are the necessities of life?
Well, those are actually defined very clearly in for instance, the what's written up by the Canadian Standards Association. But broadly speaking, giving a generic definition, the necessaries of life are the things that are necessary to allow people to live a quality of life, if they are in terms of their care, etc., and to have the care that they require based on whatever else is wrong with them, to give them a quality of life. And again, if you again look at the Charter of Rights and Freedoms under Section 7 of the Criminal Code, it defines the fact that Section 7 is the right to life, liberty, and security of the person.
Okay.
And under security of the person, it's very clear what the necessaries for making a person live a secure quality of life. And to make those definitions of what that is by themselves, that nobody can tell you what is the security of your person. You are the only person. It's all about autonomy of the individual, what the individual's needs are. But the Canadian Standards Association, if you can get your hands on it, maybe Devin can send you the link to tap into it. It can tell you some of the things that they see as very clear necessaries. The criminal code might actually have a definition of necessaries. And also, their standards are talking about protocols that are necessary, basic things like, washing your hands if you go from one patient to another, wearing a mask when there is a contagious disease around. And one of the things, obviously, that's going to be involved in this is looking at the ventilation. That's why the federal government, our government, during and after COVID, put forward a concept that said ventilation, and good ventilation is necessary if you're going to be able to prevent an airborne disease from spreading through a place, a building, a facility.
That actually really surprised me, because it was like, don't they have any emergency protocols in place already, considering they always have flu outbreaks, anyways. But so when somebody isn't able to make their own decisions, then they have what's called a substitute decision maker.
Yes.
And so I have a kind of scenario, and I wondered if you could tell me how this bill would affect that. So a situation where a doctor gives a medication to a resident without discussing it with the power of attorney or the substitute decision maker. So, and this medication was given to this by mistake, like it wasn't the right medication for this patient or this resident. And through a whole bunch of other like ridiculous errors, it took me a month to actually get an appointment with the doctor to get my mother off this medication. But the Ministry of Health and Long-Term Care can't do anything. It's just like, oh, you shouldn't have done that. The College of Physicians and Surgeons, it was a slap on his wrist. The College of Nurses, they all got slaps on it. There was nothing. Like, my mother was put on Ritalin by mistake for a month.
Oh my God.
And there was no There were no criminal, like that was ridiculous. And they didn't talk to me. They didn't come to me and ask me if I wanted her on this medication. She had dementia. She wasn't capable of making that decision. But even though it's in the Bill of Rights that she has the right to assign a substitute decision maker, they didn't discuss it with me. And there were a whole bunch of other things that they did without my knowledge.
You know, those are individual cases that are going to have to be looked at by the ethics committee of colleges of physicians and surgeons and nurses. And if they did not pay attention to it, and I can't comment on that at all. The bottom line is every physician ethically is supposed to get informed consent before they do anything on a patient. If the patient is unable to give informed consent because of mental illness or because of inability to think clearly, then there is a person who has to do that. And in this case, it was you. I cannot comment on the case because I don't know anything about it. But the bottom line is there's an ethical issue here. I don't know if the physician gave your mom Ritalin or if the physician wrote something else which was misread by the nurse who was preparing medication. I have no idea. I can't comment because I don't know what actually went on.
Yeah,
but what I'm asking is,
Trish, if I can just Mickey, if I can just interject for a moment. Issues like this have in the past been dealt with by asking the police to investigate the possibility of criminal negligence causing bodily harm. There has sometimes been some action on that where the police actually visited the doctor and investigated what actually occurred because it caused bodily harm to the person. So that can be an option. May not always work, but it has in the past.
Because the nursing and medicine are self-regulating professions and they come under provincial jurisdiction and provincial legislation where they are able, and their colleges are able to tell people whether they would take away their license or what they would do if they breach protocols. And there are clear protocols for practice of medicine and practice of nursing. So again, I don't know what happened there, and I don't know what went on and what the details are. So I really don't feel able to comment on the specific case, except to give you the general idea that physicians are bound ethically to seek informed consent, which means explaining everything before the person gives consent. And if the person is unable to do that, then there should be a person appointed to do that for the patient.
Right.
And Patricia's kind of getting at, I think is getting at what I was trying to say, or what I was trying to ask is, in a situation like this, if this bill C-95 were passed, would this have been where I could have gone to the police and said, they've got my mother on Ritalin, she shouldn't be on Ritalin, I need you to go talk to the facility?
No, I think it would be a different section of the criminal code, Mickey, was what I was getting at. I think Dr. Fry's bill basically looks at failure to provide necessaries of life. But I think criminal negligence that causes bodily harm to someone, that's another police matter, and it is under
and also criminal negligence performed, or criminal negligence of a nurse or a doctor is under the jurisdiction of the colleges of nursing and physicians.
Who have no power, just like the Ministry of Health. They don't do, like, they have
power. They have power. They can remove a person's license. They can suspend their license for a period of time. They have power.
They found that the doctor was negligent in not speaking to me, but they just gave him, they made him watch a video on getting consent.
Well, I don't really feel qualified to comment on that decision made by the college.
Yeah, I think, Dr. Fry, the competence and effectiveness of the different colleges vary also from province to province. Right. And Mickey is saying something that a lot of people have also said to us, which is that oftentimes people get a slap on the wrist for some very serious matters. So that may be unique to Ontario as well, that we've had to deal with this. But Mickey, you and I could talk after about how the criminal code might work on that. So Cecily and Trish have their hand up. So Cecily, you're next.
Well, in your bill C-295, are the necessaries of life spelled out, or is it based on what we see in the Charter of Rights and Freedoms? And if it's not spelled out in the bill for the criminal code, what is the possibility of any province invoking the notwithstanding clause so that they are not governed by this code?
Now, that's a question I cannot answer because I'm not a lawyer. I don't understand that kind of jurisdictional decision making. I'm sure you could ask 12 lawyers and they'll give you 12 different answers. But the bottom line is that at the end of the day, necessaries of life are pretty well applied to children or applied to people who are vulnerable at any point in time, what they need to make them live well, to have a quality of life, to have the care they need, food, lodging, cleanliness, change of clothing, all of those kinds of things are pretty well part of the necessaries of life. Medication if they need it, but all of those things are clearly part of the necessaries of life. So, Devin, do we have that defined in the criminal code?
The necessaries of life, I can look.
Yeah, I think it is defined. Cecily,
I think it is defined, yes.
I think the Constitution covers security of the person, and they can
Yes.
opt out of that, but they can't opt out of the Criminal Code of Canada.
No, I understand that, but I'm just saying if you say the necessaries of life as outlined in the Charter of Rights and Freedoms.
Well, they're not actually outlined in the Charter of Rights and Freedoms. It's just security of the person in the charter.
At the end of the day, the courts decide what is a violation of security of the person.
Right.
It is in the criminal code. It looks like
Yes.
section 215.
Excellent.
They
Okay,
so they can't opt out of that.
Okay, perfect. Because we know who likes to opt out.
Yes, we do.
Okay. Guys, I'm going to have to leave very soon because I have an event I have to go to. So
okay, we have one more question from Trish Rostone, and then we can wind it up.
Okay.
Just to let Mickey know that the same thing happened with me. So what I did was I contacted the lawyer who wrote up my POA and let him deal with it, and it never happened again.
Yeah.
So
and that's a good way to go, but there are some people who cannot afford to pay a lawyer, and that's why it has to be defined very clearly what we're talking about.
Yes, right. And I appreciate that comment, Dr. Fry, because we have had the same problem with human rights commissions and others where lawyers are required and people can't afford that. So you're absolutely right. And
well,
I'm glad that
actually, in terms of the Charter of Rights, if you are somebody who cannot afford to hire a lawyer, but your charter rights were violated, that's where it was brought in, I think, under Pierre Trudeau. It was called the Court Challenges Program, where people who were, by virtue of poverty or race or any kind of discrimination, could not afford to seek justice in the courts, that they could go to the Court Challenges Program, where there were a number of lawyers working, paid by the federal government, to look at their case and see if they have a case to be able to take it to the courts.
Yeah.
Now that was canceled under Brian Mulroney, and we brought it back under Chrétien. And then when Chrétien left and Martin left and Harper came in, he canceled it. And the first thing that our current Prime Minister did in 2015 was bring it back.
Oh, so that's back now, is it?
Yes. Yeah, it came back in 2015. The very first thing the Prime Minister did was bring it back.
Okay, we're going to have to pursue that in that case. I didn't know it was back again.
Yes, it's back again.
It's been taken away so often.
There is an excellent speech made by Justice Rosalie Abella of the Supreme Court of Canada, now retired, when she received the Ruth Bader Ginsburg Award recently. And her speech was about we love to talk about the rule of law, but we don't talk about the law must serve justice and not the other way around.
Right.
Rule of law alone, if it's a bad law, should not be a law that we want to encourage. But if we have a law that serves justice, laws are supposed to serve justice. And that's an important distinction that she made. It was an excellent speech, and it's something we should think about when we talk about law. If a law does not serve justice, it's not a good law.
It's interesting because I had a conversation recently with Judge Bella about exactly that. So
yeah, exactly.
So that's great. Thank you so much.
Not at all.
Okay, I know you have to go, so we're going to wind things up, but I want to thank you again for answering all these questions and for providing a great overview of Bill C-295. And now we shall all pray and lobby, hopefully.
Lobby senators.
Lobby our senators and our MPPs to get this bill through, because we need the bill desperately for people. So thank you so much.
Thankfully, there are a fair number of physicians, because the Prime Minister does not appoint senators anymore. Communities do. And so there are quite a few physicians in the Senate now. And this is good, a good thing. They're all supporting this bill. They're all supportive of patient care and patient well-being, et cetera, et cetera.
Well, we can all certainly help by putting as much pressure on as we can to get this bill through the Senate. And we'll hope and pray that it's successful, because it's so badly needed. Thank you so much, Dr. Fry, for
You're very welcome. And if you have any further questions, actually, what Devin can do is put in the chat the pal.ca/legislative info with regard to my bill. And then you can go and look at some of the other things, the definitions within the criminal code itself, because my neglect of vulnerable adults comes specifically under, is it 215? What is it, Devin? 215?
295.
Yes, of the criminal code. So you can read those.
Oh, sorry. Sorry. Section 215 of the criminal code. I thought you meant the name of the bill.
Oh, yeah. No. Yeah. Okay.
Okay.
Right.
That's
goodbye,
great.
people. I
have to go. Have a good evening, and thank you, Devin, for helping out. Okay, have a good night, everyone. We're going to end the session.